Any other questions from committee members? Mr. Lackey.
Yeah, not so much a question as it is a remark. There was, reference to the interlock device system, which is another creative opportunity that the courts are trying to utilize to address this very problem that this measure appears to address when we have repeat offenders that continue to threaten the lives of others and their own life. And so, having had the experience of being in the enforcement capacity and witnessing firsthand the tragedy as well as the arrest of individuals who are making judgments that are threatening other people and not realizing the severity of their problem, I really want to thank you for that, because the interlock system is easily defeated, unfortunately, even though it could be a deterrent in some atmospheres. The people who are determined to drive under the influence can defeat that system. And so it has some holes in it. And I think that this addresses those holes and allows people to prove that they're going to change and that they no longer want to repeat. And I think that's the intention of court, is to not get people to repeat. It's not so much the punishment piece. It's that we want rehabilitation. We want people to not threaten other people. And so I'm very appreciative of what you brought forward, and I think it's a very meaningful remedy for the problem that we all face, whether we realize it or not. Every time you drive at nighttime, and even during the daytime, there are people that shouldn't be driving out there. And heaven forbid that they run into us and cause tragedy. So thank you.
Very good. Thank you, Mr. Lackey.
Okay. Are there any other questions from committee members? You may close.
Well, I request your aye vote. I do want to note that the bill came to me sort of through the policy channel. So there are people out there that design devices suitable for this, but they are not the source of the bill. The bill came, as I say, through the policy consideration. And only later did I learn that there was someone actually in California that had this type of device. So I request your aye vote.
Okay. Do we have a motion?
So moved.
Second. Mr. Lackey moves. Mr. Santiago seconds. The chair recommends an aye vote. And I want to thank Mr. Cooley for working with staff to make this a better bill. And I thank the members for the questions. I think it was appropriate.
Very good.
The motion is due pass to transportation. Jones Sawyer?
Aye.
Jones Sawyer, aye. Melendez? Melendez not voting. Lackey?
Aye.
Lackey, aye. Lopez? Lowe? Lowe, aye. Quirk? Santiago? Santiago, aye.
That bill passes. Is out of committee.
Okay. Very good. Thank you.
And you have one other item, 2327, item number 20.
Yes, very good. And I'll be very good. Mr. Chair and members, I'm here today to present AB 2327, which regards human trafficking and sentencing for inappropriate contact with minors. It's estimated that every year about 500,000 American youth are at risk for being sold for sex in the United States, 500,000. In recent years, law enforcement has seen a growing use of the internet to lure children into destructive situations where such exploitation and sexual assault can and does occur. Existing law outlines punishment for luring a minor with the intent of committing a number of offenses involving that minor, which includes kidnapping and rape. But human trafficking is not included among the offenses currently outlined. So it's sort of a hole in the statutory scheme. AB 2327 adds human trafficking to this list of offenses for which it may be considered a crime to engage or attempt to engage in contact with a minor. The bill will help law enforcement target such traffickers more effectively, allowing law enforcement to adapt to the increased use of the internet by traffickers to lure their victims. And here today to testify in support is District Attorney Nancy O'Malley from Alameda County, who has been in the vanguard of prosecution in this area. So she's my subject matter expert. So Ms. O'Malley.
Okay.
Thank you. Good morning, Mr. Chair and members.
You have
Nice
2
to see
minutes
you.
and you have to present.
Thank you. I am Nancy O'Malley, the district attorney from Alameda County, and the bill that the legislation would amend was passed by your legislature some years back, and we really call it the luring bill because it's about luring children into a dangerous situation, including sexual assault, child abuse, pornography, things like that. What we didn't realize back then, when this bill was passed, was the high incident of human trafficking of minors. And what we're seeing now is the internet has become a very dangerous place for children. At any given time, if a website is taken down, it's only a matter of time before a new one pops up. And we've been looking at this through the HEAT Institute, a research institute. We've been taking testimony throughout the state for the last several months about all of these sites that are popping up that are advertising children for sale. The law has been the law is very strong now that gives us the tools to prosecute the traffickers, those that are putting a minor online or in the life. But what this bill does is it really addresses the predators, the person who is purchasing the child. And right now, the laws are not strong at all. In fact, there's really only one law that applies to an adult who's purchasing a minor for sex, either on the internet or on the street or in some other way, and that is 647B, a misdemeanor. This is a child protection law, and it's really, as I said, aimed at getting to the purchasers. Without the purchasers who are really feeding the demand, that we would have a much stronger impact on being able to stop human trafficking, particularly of children, in the first place. So we urge an aye vote.
Thank you.
Move the bill.
John Lovell, and let me simply incorporate by reference the 8 law enforcement organizations I represent from the previous testimony. This is an important bill closing a hole. The fact is that human trafficking is a highly organized and sophisticated criminal operation. About 2 weeks ago, I was watching a news show on Azteca America, and one of the announcers, and this was chilling, she was talking about the income stream of the cartels, and she was saying that new business trend, human trafficking is now the second largest income stream of the cartels. And she went on breathlessly, ahead of kidnapping, ahead of extortion, ahead of murder for hire. And this is an incredibly complex operation. This bill closes an important hole that was frankly an oversight from the beginning, because when the original luring law was enacted, and I was part of that effort, we didn't really have the awareness of human trafficking that we have today. This is a very important bill.
Okay. Thank you. Are there anyone to speak in support? Your name and organization.
Good morning. Danielle Mollet, California Alliance of Child and Family Services, in support.
Thank you.
Good morning, Mr. Chair and committee members. Asha Harris on behalf of the California State Sheriff's Association, in support.
Thank you very much.
Good morning. Morgan Geyer on behalf of the Sacramento County District Attorney's Office, in support of this bill.
Thank you, sir. Are there any witnesses in opposition?
Good morning, Mr. Chair, members. Micah Doctoroff on behalf of the ACLU of California, here in respectful opposition to the bill. We share the Assembly members' important goal of protecting young people. However, we do not believe that this bill is necessary to accomplish that goal. A person can already be convicted and punished for engaging in the conduct contemplated by the bill under existing criminal laws. Therefore, we think this bill is unnecessary, and that is the substance of our opposition.
Thank you.
Khalif Asagai on behalf of the California Public Defenders Association. We weren't able to get a letter in before the hearing, but we have adopted an opposed position. We have significant concerns with this bill, and we'll associate our comments with those of the ACLU.
Thank you. Are there any witnesses in opposition? State your name and organization.
Good morning, Chair and members. Dennis Cuevas Romero with the Hernandez Strategy Group, here on behalf of the California Attorneys for Criminal Justice, in regrettable opposition.
All right. Thank you. Members, do you have any questions? It's been properly moved and seconded. You can, your closing statement.
I request an aye vote, and I do. I've heard from the opposition. I've just said I'll continue to listen to them, but obviously, looking at how we safeguard children in this era, I think the conversation should proceed. So I request an aye vote.
And the chair recommending aye, and I believe Mr. Cooley is sincere when he says he will work with the opposition to ensure that no one's rights are abridged. But the most important thing right now is that we protect people who are involved in this activity right now.
The motion is due pass to appropriations. Jones Sawyer.
Aye.
Jones Sawyer, aye. Melendez. Melendez, aye. Lackey. Lackey, aye. Lopez. Lowe. Lowe, aye. Quirk. Quirk, aye. Santiago.
Bill passes. Congratulations. Thank you. All right. And we'll now do the vote on the consent calendar. AB 1924 Bigelow, pen register track and trace devices orders. AB 1953 Weber, peace officers civilian complaints. AB 2061 Waldron, supervised population workforce training grant program. AB 2160 Bonta, crime victims compensations for pecuniary loss. AB 2505 Quirk, animals euthanasia. These are on the proposed consent calendar. Madam Secretary, call the roll.
Jones Sawyer.
Aye.
Jones Sawyer, aye. Melendez. Melendez, aye. Lackey. Lackey, aye. Lopez. Lowe. Lowe, aye. Quirk. Quirk, aye. Santiago.
Consent calendar is adopted. And we now have Mr. Bigelow. 2012, item number 4.
Good morning, Mr. Chairman and members. I'm here today to request an aye vote on AB 2012, which I am joint authoring with my colleagues, the Chairman, Mr. Jones Sawyer, Mr. Cooper, and Assemblyman Wilk. AB 2012 will authorize the Board of Supervisors of specific counties to authorize the county sheriff or county director of corrections to create a jail industry program. The industry's programs provide benefits not only to the inmate but to the community as well. They benefit the inmates by rewarding good behavior and, most importantly, providing vocational skills so inmates can better be prepared to be hired upon their release. The community benefits by proven reduction in recidivism rates that industry provides. The counties currently listed under AB 2012 are Los Angeles, Sacramento, San Diego, San Joaquin, Sonoma, Tulare, Tuolumne, and Ventura. But I'm open to including whomever comes forward. We already have a couple that are under an existing action that allows this. I would like to thank you for your time. And with me today, I have John Fisher from the Tuolumne County Sheriff's Office and Lieutenant Wayne Belote from the Los Angeles County Sheriff's Office, the measure's co-authors.
Move the bill.
Marla, you're here. I'm sorry, Marla's here instead.
We have a motion to move. Do we have a second?
We have a motion and a second?
Yes.
Well, Mr. Chairman, if there's any questions.
The witnesses, they have 2 minutes.
Let me just ask.
Okay.
The sponsors are here,
Mm-hmm.
but if there's any questions that we could answer directly, I'd be happy to just shorten this because I know you have a long hearing.
I will. Well, some of them come a long way. If they take just 2 minutes, then we're good. Or you'll go straight to questions? All right. Then are there, before we go to questions, are there anyone else in favor of the bill that would like to say their name and organization they belong to?
Hi, Darby Kernan with the California State Association of Counties, in support.
Good morning, Mr. Chair and members. Corey Salzillo here on behalf of the California State Sheriff's Association in support.
Thank you. Is there anyone in opposition of the bill? No? With that, are there any questions from any of the committee members? I just had one. So this will be the Jail Industry Authority, because program JIP, just, for a prison program, just rubs me the wrong way.
Mr. Chairman, I completely understand your question on that, and yes, we're going to work on changing the acronym of this so it has a much more appropriate acronym. So the overall name will change slightly to reflect a more positive outcome.
Thank you. Thank you. With that, we have a motion and second. Let's go to the vote. You have a closing statement?
I and we would strongly encourage an aye vote today.
And the chair is recommending an aye vote. So.
Item number 10, AB 2012. The motion is due pass. Jones Sawyer.
Aye.
Jones Sawyer, aye. Melendez. Lackey. Aye. Lackey, aye. Lopez. Lowe. Lowe, aye. Quirk.
Aye.
Quirk, aye. Santiago.
That bill passes.
Thank you, Mr. Chairman. Thank you, members.
You're welcome. And Assemblywoman Kim, bill number 2078, item number 13, protective orders. Whenever you're ready.
Thank you, Chairman and the members. I'm pleased to present AB 2078, which is really a technical cleanup bill. To put it simply, this bill would correct a drafting error in the penal code that recognizes the willful violation of domestic violence restraining orders to also be considered a contempt of court. AB 2078 would conform the punishments for a violation of a post-conviction domestic violence restraining orders consistent to that for other post-conviction restraining orders against defendants convicted of abuse. As it currently stands, a cross-reference was inadvertently omitted from the contempt of court statute, which, among other things, describes the punishment for violating restraining orders. Due to this drafting error in our current law, if violators of restraining orders pursuant to Penal Code Section 273.5J are not also listed in the Penal Code Section 166 Subdivision C, the perpetrator cannot be appropriately charged for stronger penalties for violations of court restraining and protective orders relating to sexual assault, elder abuse, and domestic violence-related crimes. Every 9 seconds, a woman is assaulted in the United States, and nearly 20 people per minute are physically abused by their intimate partner. Restraining orders are one of the best ways to protect our victims of domestic violence from further abuse. The courts may issue a protective order to potential victims of domestic violence if the judge finds that there is good cause to believe that harm, intimidation, or dissuasion of a victim or witness has occurred or is likely to occur. So if this sounds like a technical bill, then you're right. It is. By making the appropriate cross-reference in the Penal Code, AB 2078 closes a loophole, ensuring that all those who willfully violate domestic violence restraining orders are held accountable. So with me this morning to speak on the bill is, thank you, I would like my witness to say a few words. Sarah Dabuski from Santa Cruz County DA's office.
Good morning, Mr. Chairman, members of the committee. My name is Sarah Dubkowski. I'm Assistant District Attorney in Santa Cruz County. I've been a prosecutor for about 7 years. When domestic violence perpetrators violate criminal protective orders, they should be charged and punished under the appropriate domestic violence contempt of court section, which is Penal Code Section 166C. However, under the current law, certain protective orders, the ones focused on in this bill under 273.5J, are not listed under that appropriate contempt section. And the legislature has done enormous things, wonderful things for domestic violence victims. This just seems to be an oversight. And the context is important because these particular protective orders are usually issued for the most serious offenders, for people who are sent to prison after causing injury on domestic violence victims based on significant injury or if they have enough priors, or another context where the 3-year protective order just isn't enough to ensure the safety of those particular victims, and they need a protective order for sometimes 5 or 10 years. So these are the most serious offenders, but when they violate these protective orders, they can actually receive a lesser punishment than other domestic violence perpetrators, a lesser punishment than even those convicted of a misdemeanor who are placed on probation and not given any jail time. And their punishment when violating the protective order would not include the appropriate domestic violence terms, such as the batter's treatment program, paying fines and fees to women's shelters, and also completing appropriate volunteer service. So the punishment and consequences should be the same across the board for people who violate domestic violence criminal protective orders. I urge you to close this loophole, and I urge an aye vote on this bill. Thank you.
Thank you. Are there anyone speaking on behalf, name and organization?
Sean Hoffman with the California District Attorneys Association in support.
Thank you.
Asha Harris on behalf of the California State Sheriff's Association in support.
Thank you.
John Lovell on behalf of the California College and University Police Chiefs in support. What you may not realize is that domestic violence incidents take place disproportionately in a campus environment. This is an important bill.
Are there any witnesses in opposition? No? Seeing none? I know we had a motion, we had a second. Are there any questions from any of the members or comments?
Thank you, Mr. Chairman. Ms. Kim, I want to thank you for bringing this bill forward. This is my 4th year now on the Public Safety Committee, and for 4 years we've heard a variety of bills, and I have to tell you I've come to the conclusion that when it comes to crime and punishment and justice for victims, women and children always seem to be on the short end of this stick, for that matter. I don't know why that is, but it does seem that we don't take as seriously crimes that are committed against women, crimes that are committed against children. So I'm happy that you brought this bill forward. It's not going to solve the problem, certainly, but it can help. It can save one woman from getting the tar beat out of her. It can save one child from getting knocked across the room because his father came home drunk again, or any variety of circumstances that we know exist out there. So I want to thank you, and I'm happy to support your bill.
Thank you.
Any other questions or comments? You may close, Ms. Kim.
I simply ask for your aye vote.
Thank you. The chair is going to recommend an aye, and I want to thank Ms. Kim for bringing this to the committee. But I especially want to thank you for working with the committee. By doing that, you're actually solving the problem, not just creating a whole bunch of bills that we just pass and pass and pass, which doesn't really address the solution. You hit it right on the head. You're solving the problem, and this committee thanks you for that, because if we get more bills like this, I think we will show demonstrably not only that every committee member here cares about women and battered women and domestic violence, but we're willing to pass laws like yours that will help in that manner. So thank you for bringing this to the committee.
Thank you.
AB 2078, the motion is due pass to appropriations. Jones Sawyer?
Aye.
Jones Sawyer, aye. Melendez? Melendez, aye. Lackey? Lopez? Lowe? Lowe, aye. Quirk?
Aye.
Quirk, aye. Santiago?
That bill is out. Thank you.
Appreciate it.
He's here, but she's been waiting. Okay. Ms. Waldron? AB 2227, item number 16.
Thank you, Mr. Chair and committee. I'm here today to present Assembly Bill 2227 in committee mock-up form. I would like to thank the chair and committee for working with us on this bill. This idea for the bill came from a police officer with the Escondido Police Department after they faced difficulties prosecuting individuals with different license suspensions who were subsequently involved in reckless driving bodily injury accidents. AB 2227 makes it unlawful for a person driving a vehicle with a suspended or revoked license for reckless driving to commit an illegal act while driving a vehicle where the act or neglect causes bodily injury to a person other than the driver. This bill will also require the minimum sentence for that offense. Currently, California's driving unsuspended license offense is a misdemeanor crime that subjects offenders to possible county jail time and substantial fines. This crime is treated differently depending on why a license was suspended or revoked in the first place. Despite the law, 2/3 of offenders still continue to drive while under suspension. This bill is important for public safety to keep reckless drivers off the road. AB 2227 is supported by the Police Chiefs Association. Here I have with me Jonathan Feldman, representing the Police Chiefs Association in support. Thank you.
Move the bill.
Good morning, Chair and members. Jonathan Feldman with the California Police Chiefs Association. This bill was generated from one of our police departments after an officer had repeated occurrences of drivers with licenses suspended for reckless driving being involved in traffic accidents that resulted in injured victims. Unfortunately for those victims, the current penalty for causing bodily harm under those circumstances can be no more than a few days in jail and a small fine. If those drivers had suspended licenses for DUI offenses, they would be subject to a range of penalties depending on the facts of the case and any prior DUI convictions, the least of which would be a misdemeanor. Cal Chiefs would argue that the poor decision-making that leads to someone driving recklessly, which is defined in Vehicle Code Section 23103 as driving with willful or wanton disregard for public safety, is comparable to the disregard shown by a DUI offender. So we see these as very similar penalties that resulting in the suspension of the license. To enable a prosecutor, therefore, to charge comparable penalties under these circumstances is justifiable to ensure terms proportionate to the seriousness of the offense and uniformity in the sentence of offenders committing the same offense under similar circumstances. Although we are all fully aware that legislation creating new penalties is unlikely to succeed this year, we see this bill as not creating a new penalty, but rather using existing penalties to address a public safety concern that is not being met under current law, and we would request your aye vote.
Thank you. Are there any other witnesses that you have? None?
No.
Anyone in favor of the bill? Anyone else like to speak in favor? Are there anyone in opposition to the bill? Seeing none, are there any questions from committee members? Okay. Your closing statement?
I urge an aye vote, and thank you so much for working with us on the bill.
Okay, and the chair recommending an aye vote. Good.
AB 2227, the motion is due pass as amended to transportation. Jones Sawyer?
Aye.
Jones Sawyer, aye. Melendez? Melendez, aye. Lackey? Lackey, aye. Lopez? Lowe? Lowe, aye. Quirk?
Aye.
Quirk, aye. Santiago?
That bill passes. Congratulations.
Thank you so much.
You're welcome.